is more persuasive. You know, it really. So this isn't a course to try to indoctrinate you. This is a course really try to explain to you what the respective positions are that one can expect in the near future to be manifest, so you can determine if you want to participate in this upcoming contest between these two worldviews in dealing with massive global climate change and the rise of this national security state. You'll know what the issues are. I hope we don't turn out another Rehnquist out of this class that can figure out. I should tell you, just in opening onto this subject, there was and I should have gone and found it, but it just makes me remember it now, is that Rehnquist, soon after he got on the court, he wrote an opinion. There's a federal law that mandates that any U.S. federal government contractor has to provide equal insurance services and things, cannot discriminate against women based on gender. And there was a company that had a major federal contract that in fact provided insurance, health insurance for men to actually even get knee replacements if they injured their knee playing touch football on the company touch football team, and also for hair transplants for men. But they denied women pregnancy benefits. And so, and it's not even just birth control or abortion funding. It was, any type of health benefits relating to pregnancy. And Rehnquist was capable of articulating an argument pursuant to which he said that this conduct on the part of the insurance company and that corporation did not violate the Equal Protection Clause because it denied benefits both to non-pregnant women and non-pregnant men. And so therefore it was not discriminatory. So what you can see there is that there is a capacity that lawyers have to confabulate an argument that just simply ignores some absolutely underlying dimension of reality, that they think they can just kind of slip it right on by you, that you haven't noticed that there's something profoundly wrong with what they're saying. But that it isn't always as obvious as that particular case, but it happens a lot. And in this particular case of the Equal Rights Amendment, now you remember that the 14th Amendment, has five operative principles. The first one was that all persons born or naturalized in the U.S. are citizens of the United States and of the state in which they reside. This had the effect of making black people, the African American people that have been brought over here forcibly and put into slavery, and Native American people that had also been not counted as citizens. It made them citizens of the United States. And the second provision was, as we touched upon, that no state shall make or enforce any law that shall abridge the privileges or immunities of citizens of the United States. And the third provision was, no state shall deprive any person of life, liberty, or property without the due process of law. And we covered both the procedural aspects to due process of law and the substantive due process of law. And today we're going to look at the fourth of the five and the fifth. The fourth one says, no state shall deny to any person within its jurisdiction the equal protection of the laws. And the fifth principle is that the United States Congress is hereby authorized by this constitutional amendment, the 14th, to pass federal laws to enforce these protections. Okay? And so what we saw, however, is, remember, right away, within 5 years of the passage or the ratification of the 14th Amendment, the United States Supreme Court, Justice Miller, writing the opinion for them, wrote an opinion in the Slaughterhouse Cases in which he said that the rights, privileges, and immunities of citizens of the United States were restricted just to those narrow rights that were absolutely indispensable for the federal citizenship. That is, the right to go to the national capital and present a petition for grievances, the right to go to the seaports, the right to participate. Those who were authorized to vote in the states would be authorized to vote in the federal elections. But even then, the right to vote was still done on the state level. They only voted basically for members of the Electoral College, and they voted for state legislators. And the state legislators selected the United States senators, and the Electoral College people that they voted for got together and chose the president. So that this very first case, the Slaughterhouse Cases, decided that rights, privileges, and immunities of citizens of the United States applied only to this extraordinarily narrow band of cases of rights. And so therefore, one of the major intents of the people who introduced and passed the 14th Amendment to make sure that all of the fundamental rights that belong to people were given equally to everybody was basically derailed. And so what happened is that the proponents of a natural law worldview looked to other portions of the 14th Amendment to attempt to shoehorn into those other concepts what they had originally intended to be included under the rights, privileges, and immunities of citizens of the United States. So they went to the Due Process Clause, and through this process of selective inclusion, one by one, included into the mandates for due process of law, not only the procedural safeguards that were understood to be necessary under the Fifth Amendment Due Process Clause, to apply them to the states under the 14th Amendment Due Process Clause, but also they began this process of the substantive due process of saying that, look, there are just certain things that even state governments can't do. Like you can't, for example, like in Skinner versus Oklahoma, you can't just sterilize somebody because they've had 3 offenses, because there's no rational connection. It doesn't make any sense to do that. And of course, it could have been found that it was a cruel and unusual punishment under the 8th Amendment. But I want to point out that right in the Slaughterhouse Cases themselves, and it's a little bit confusing because it's a single case, but there were a number of cases that all came up together on it, that even Justice Miller, in his opinion, what he was doing is, because it was only 5 years after the ratification of the 14th Amendment, he felt compelled, or disposed at least, to explicate in some detail all kinds of the provisions that were in the 14th Amendment, other than just these rights, privileges, and immunities of citizens of the United States on which the case turned. He, for example, pointed out on the 13th page of that opinion, he said the following. He said, no one can fail to be impressed with the one pervading purpose found in all of the provisions of the 13th, 14th, and 15th Amendments, lying at the very foundation of each, and without which none of them would have ever been suggested. We mean the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made freedmen and the new citizens from oppression of those who had formerly exercised unlimited dominion over them. We do not mean to say here that no one else but the Negro race can share in this protection, but the language and spirit of these articles are to have their fair and just weight in any question of construction. And he says, undoubtedly, while Negro slavery alone was in the mind of the Congress which proposed the 13th and 14th Amendments, the 13th forbids any kind of slavery, nor now or hereafter. So therefore, if the Mexican peonage or the Chinese coolie labor system were to develop into a system of slavery of the Mexicans or the Chinese race within our country, this amendment would surely make that void. And so, if other rights are assailed by the states, which properly and necessarily fall within the protection of these articles, the protection will apply, though the party interested may not be of African descent. So you see what's happened here. Even though the Supreme Court in the Slaughterhouse case actually denied the broad understanding of rights, privileges, and immunities of citizens of the United States, they gave a reading to the equal protection provisions, which seemed to go beyond providing equal protection just to members of the African race, and specifically included the Chinese and Mexican people. So there's a principle that has been acknowledged right in the very first United States Supreme Court case that in that case didn't deal with the equal protection. It dealt with what were the rights, privileges, and immunities of citizens of the United States, given the way the case had been crafted that came to them. But he felt constrained to go forward and talk about the equal rights, the equal protection clause, and actually acknowledge that it would apply to people other than members of the African race. So the question that was posed right away then, as of 1872 even, is to what extent and in what manner is our national and constitutional experience with racial discrimination against the black race able to be generalized into a set of general principles against some sort of class-based discrimination that can be imposed against both the federal and state governments, and can it be enforced against private people, private conspiracy groups? Can it be enforced against private individuals who are going to be depriving anybody of the equal rights? And what happened is there were two statutes passed by Congress immediately following the ratification of the 14th Amendment. The first one in 1870 was the Civil Rights Enforcement Act. And this is an extraordinarily important statute because it made it a federal felony offense for any two or more people to conspire together to injure, oppress, threaten, or intimidate any citizen of the United States with the intent to prevent or hinder the free exercise of any right granted by the federal Constitution or by any of the laws of the United States. Now this is a very far-reaching federal statute, this 1870 Enforcement Act, because what it basically does is it establishes a new federal tort, a tort claim where a person can bring an action in a federal court charging that there's been a group that's conspired to interfere with or with the intent to intimidate or hinder them in the exercise of their fundamental rights. Okay? Now, they also passed in 1871, the year after that, an act which has come to be called the Ku Klux Klan Act. And what it does is it says, it shall be a crime to conspire to deprive any person or any class of persons of the equal protection of the laws. So you can see that right away that the Congress itself was perceiving there being two different sets of rights here. There are these fundamental rights in general that people have, but on the other hand, there's this right to the equal protection of the law. And that they've passed statutes now generating both a criminal and civil liability to anyone who does this. But you'll notice that both of the statutes required that the person conspire to violate these rights. But they're clearly directed against private parties. And even though they didn't make the tort available to sue just an individual who was going to violate your fundamental rights. or your right to equal protection of the laws. It had to be a conspiracy group. But what happened is right away, that was passed in 1870 and 1871. In 1875, the United States Supreme Court, in a case called U.S. v. Reese, R-E-E-S-E, that is in the 92nd volume of the Supreme Court opinions at 214, they declared that the Civil Rights Enforcement Act that was passed by Congress on its face is unconstitutional because it had swept up people who engaged in planning to violate somebody's civil rights, and it didn't require that they had to be motivated by an anti-racial animus. So right away they went after the core of that 1870 Act that had in general prohibited anybody from conspiring together to violate anybody's civil rights. They restricted it to just those cases where they were motivated by an anti-racial bias. Okay, and so they cut out the authority to enforce and protect all fundamental constitutional rights. And so right away, within just 4 years of the passage of these statutes, it was declared unconstitutional. And in U.S. v. Cruikshank, just in that same year, the Supreme Court, in the same report, same volume, in volume 92 of the U.S. Supreme Court reports, at page 542, they actually struck down the application of this statute against 3 white men that had lynched 2 black men. And they said that the reason that they did it, they said because the complaint failed to allege that the reason that they lynched the 2 men was because the men were trying to exercise some extremely narrow federal right, like petitioning the government for a redress of grievances. So you saw what they did is they backed up and they took the ruling in the Slaughterhouse case that confined the rights, privileges, and immunities of a citizen of the United States, and they said, oh, you can't enforce any of these statutes against anybody who is trying to violate some other fundamental right other than these narrow rights that are exclusively designed to enable you to function as a federal citizen. Okay? And so that they, in that same year, in 1875, within 5 years of passing the Civil Rights Enforcement Statute and the Ku Klux Klan Act, the Supreme Court had basically disemboweled the 2 federal statutes that were designed to protect people. And they then went on to assert that in the next case that came down, in the United States versus Harris in 1882, this is about 10 years later, 8 years later, they struck down the entire Ku Klux Klan Act, flat out saying that the 14th Amendment does not authorize the federal government to pass a statute enforcing these rights against any conspiracy group of individuals unless there is state action involved. Because they said that the 14th Amendment is clearly designed simply to restrict the authority of states to engage in action that violate these fundamental rights of citizens. And so they asserted that the federal government had no authority whatsoever to enforce the Equal Rights Amendment against any individuals, private individuals, or any conspiracy group of private individuals unless there were state action involved. And so what you can see here is there is this extremely hostile attitude being adopted by the Supreme Court toward the very spirit of the 14th Amendment. And that is because, as it turned out, this was all predicated upon a turn in the political climate. In 1876, right at this period where the 1875 decisions were coming out and the 1884 decision. What had happened in 1876, there was a major political crisis that occurred in the country. In the presidential election of 1876, it turns out that Samuel Tilden, for the Democrats, had won the popular vote, but Rutherford B. Hayes had won the Electoral College votes. And so there was a big confrontation about this, and the Congress convened to try to determine what they were going to do about this. And it turns out that the Democrats agreed to vote to withdraw the federal troops that had been stationed in the southern states and to approve the authority of Southerners to be appointed to the presidential cabinet if, in fact, if the people in the Congress would vote to seat Rutherford B. Hayes. And so there was a straight-up political compromise that was made, pursuant to which they opened up the floodgates. They took the troops out of the South, and they allowed the Southerners to start coming into positions of power in the federal government. And so that what happened is there was this understandable shift that took place back toward the reactionary direction, because they wanted to return to the position where there was an authoritarian regime that existed under the first paradigm worldview of absolutely prohibiting any rights to the black race, and also not providing any federal protection for any of the other fundamental rights to anybody over and against the states. So the very purpose of the 14th Amendment and the 13th Amendment, for that matter, were being opposed by the Southern senators and Southern Congresspeople. And so what they did is they just dragged it back, and what they did is they utilized their intellectual acuity to make the argument that, well, wait a second, isn't it perfectly obvious that these 13th, 14th, and 15th Amendments were enacted solely to provide protection for black people? And so therefore, and restricted in that case even only to the exercise by black people of those unique and limited number of rights that were essential for the practice of federal citizenship. Okay? And they were consistent in that because they actually ruled in a case that in fact the efforts on the part of a conspiracy group to retaliate against black people for attempting to vote in the congressional election for congresspeople was reachable under the statute. So that they maintained a certain amount of intellectual integrity in their position, but they said that even black people were only protected in the exercise of that narrow band of rights that were exclusively essential for practicing one's federal citizenship. But otherwise, there was just a systematic hostility toward the equal rights of people in general. Now, there are two major cases that I litigated that are pertinent to this whole equal rights and equal protection provision. One of them was in the Silkwood case. The case of Karen Silkwood, the young 30-year-old woman who was killed up at a nuclear facility in Oklahoma. It was the Kerr-McGee nuclear facility where they reprocess spent nuclear fuel from the 103 nuclear power plants around the country. They moved some of the waste to the Kerr-McGee nuclear facility, and they grind it all up, and then they put it through centrifuges, and they spin out the 98% pure bomb-grade plutonium. And then they would compress that into these little pellets and put them in these big steel tubes and seal them off and ship them to the Hanford nuclear facility, to the fast flux test facility in Hanford, Washington. And what happened is Karen Silkwood was attacked on the highway when she was attempting to go to a meeting with David Burnham of the New York Times to deliver to him documents that she had copied out of the Kerr-McGee Nuclear Corporation's files, which showed that they were missing 40 pounds of 98% pure bomb-grade plutonium from the facility, which was enough to make 4 nuclear bombs that were each twice the strength of the bombs dropped on Hiroshima in Nagasaki. And so she was attacked on the highway and rammed and run off the road and killed. And the documents were all taken out of her car. Fortunately, we were able to get a deposition that established clearly what had happened, that these documents had all been taken out of her car because we had an eyewitness to that happening. But the bottom line is that when we discovered that plutonium was being smuggled with the assistance of the American Central Intelligence Agency to the state of Israel and to Iran to provide nuclear weapons for them, as well as South Africa and Brazil, I submitted an affidavit to the federal court in Oklahoma explaining to them what was happening with these materials, and immediately the judge called me and said that he had felt compelled to share my affidavit with the lawyer from the FBI, because the FBI, there were FBI agents that were co-defendants in the case we were doing, and he'd been immediately contacted by the Central Intelligence Agency, and they wanted to have an ex parte in-camera meeting with him immediately, and they wanted to be sure that I was excluded from the meeting. And Judge Tice felt compelled to call me and let me know that this was happening, and he invited me to come in to be in the courtroom the next Monday morning. So I show up there at 9 o'clock, and he was there on the bench, and within a matter of a couple minutes, in comes Glenn Whitaker, the attorney for the FBI, along with these 4 suits that were with him. And they came in, and Judge Tice announced that he was going to be going into chambers with them to have this conference, and that he knew that I objected to this, and he'd put my objection on the record. But then he went into chambers with them. Within a few minutes, Seymour Hersh came into the courthouse, into the room, and came over to me and said, "Danny, what's going on? What's going on here?" And I explained to him that we had found the source of plutonium that was being smuggled to Israel to make their atomic bombs. And he said, "Oh, they're never going to let you have that one." And I said, that's like the Kennedy assassination. He said, "That's just a black hole, and they're not going to let you get at that one." And a short while later, Judge Tice comes back out, gets up on the bench, and he says, "Well, Mr. Sheehan," he said, "you can be certain that it's sinister, but it's also most definitely secret. This is just a glass mountain that you're not going to be allowed to climb in this case." And so I am at this moment taking judicial notice of the fact that your count number 1 in your civil case is predicated upon the Federal Civil Rights Act of 1870 and then 1871. And I'm taking judicial notice of the fact that they were both passed immediately after the Civil War, and that the Civil War was fought solely for the purpose of freeing the black race from slavery. And therefore, I'm ruling at this point in time that the Civil Rights Act applies only to black people. And since you have not alleged anywhere within the 4 corners of your complaint that Ms. Silkwood was a member of the Negro race, I'm hereby dismissing your count. So the fact that her Fourth Amendment rights were violated by them sneaking into her home and placing electronic listening devices in her home, the fact that they had wiretapped her telephones, the fact that they had contaminated her food in her refrigerator with 400,000 disintegrations per minute of radioactive plutonium, the fact that they had chased her down on the highway where she has the First Amendment right to freedom of travel, and had rammed her into this concrete abutment, and stopped her from meeting with the New York Times, which was a violation of her First Amendment right to freedom of the press and freedom of speech, and that they deprived her of her life by killing her. That none of these things were going to be actionable, he said, because the Federal Civil Rights Act protects only black people. And he said that you can take this up on appeal, and if the 10th Circuit Court of Appeals chooses to reverse this by the time we go to trial next week, I'll reinsert this into the case. But otherwise, we're going to have to go on and try the case under count 2, which is just her radioactive contamination of herself and her home. And we went forward with that and won a $10.5 million judgment for her children, the largest judgment in the history of the United States as of that point. But the appeal that we had lodged on count 1 was declared to be moot because we'd already won the largest judgment in history. We'd only sued them for $11 million, and we won $10.5 million. And so that's one of the major cases that came up on the issue of the Equal Rights Amendment. And I prepared a major brief for the federal court in Oklahoma laying out the whole history of the Equal Rights Amendment in the 14th Amendment, and the fact that these rights were intended by the framers, Bingham and others, to actually to give federal protection to these individual rights, and that it wasn't necessary for them to be a member of the black race at all. And he clearly knew I was right, Judge Tice, but he realized that this was going to be so explosive, this case, if this evidence was allowed to go in, that it was going to be disruptive of the alliance that both the Republican and Democratic Party had with each other. And so that he struck it down, saying, look, if the 10th Circuit Court of Appeals wants to overrule me, that's fine. But I'm not going to take the weight in having this thing go to trial. In the other case I did in the Supreme Court was Mancari versus Morton, which ended up being designated at the Supreme Court level as Morton versus Mancari, because we had won at the district court level and the Circuit Court of Appeals level. And so they were the plaintiffs in front of the Supreme Court. But this was the case in which I drafted the briefs for the American Civil Liberties Union, stating that for the Bureau of Indian Affairs of the Department of Interior to engage in discriminatory hiring on behalf of Native American people was not a violation of the 14th Amendment Equal Protection Clause. And we prevailed on that in the United States Supreme Court. So I've done 2 of these cases that went all the way to the Supreme Court on this equal protection issue. But that was just so that you'll know what some of those cases look like. But the bottom line is, as I point out, that the reason why there was such a persistent attack upon the efficacy of the 14th Amendment, both its due process clause and its equal protection clause, as well as its right, privileges, and immunities clause, immediately following the Civil War, is because of this political compromise that was struck on the part of the Democratic Party to try to get Rutherford B. Hayes elected. And so that's what happened. So in fact, if you trace the evolving history of this, you'll see that it was all the way up to 1938 when, in fact, the liberal Democratic Party came back into power with Roosevelt. That Roosevelt was elected in 1932, just after the major depression started, 1929. And Roosevelt engaged in appointing to the court liberals to the court, and so by 1938, the content, the ideological content of the court started to change. And by 1938, in the case of Missouri, ex rel. Gaines, that they actually entered a ruling saying that the Missouri state legislature's statute that was passed, what happened, the state of Missouri wouldn't allow any black people to go to their law school. But they passed a statute thinking it was going to help them get around it by saying that they would help pay for the tuition of any black student who had applied to the law school, who was qualified to come to the law school, but for their race. They would pay for them to go to law school in one of the nearby states. Fortunately, the United States Supreme Court struck that down, saying that it was clear that that was a blatantly racially discriminatory statute. And so they declared it to be illegal. And so that under the Equal Rights Amendment. And that process continued all the way from 1938 all the way up to 1954. There was a process by means of which the United States Supreme Court, because of its growingly more and more moderate to progressive ideology, was now taking steps to enforce the Equal Protection Clause of the Supreme Court, or of the 14th Amendment. And so what they did is they went through this process, and I don't want to get too far down into the weeds on this because this isn't a law school course, but I want to just make it some important points here to you. What they first started doing is they were saying, look, it's clear that at a minimum, the equal rights, the Equal Protection Clause in the 14th Amendment was designed to protect black people. And because the Supreme Court, even in the Slaughterhouse case, acknowledged that it would apply to Mexicans or Chinese if they were discriminated against, because they said that it had to have some kind of a rational basis to make it connected to what the purpose of the statute was, to protect black people. And if you could show that there was another group that was like the black race that was being discriminated against, you could then get the support of the court. And so what they did is the least protective standard is that they would allow all other discriminatory statutes to pass muster so long as they had a simple rational basis for the statute, and a rational basis for discriminating against some group that was adversely impacted in a disproportionate manner by the statute. As long as they had some rational connection between the objective of the statute and the purpose of the statute passed by the state legislature was a legitimate government purpose, then they would allow that to happen. They would allow the statute to stand. But what you can see is they were actually functioning under a substantive due process standard, as distinct from an equal protection standard in and of itself. That what they were saying is if a law had been passed discriminating against some group of people, but that it had no rational basis, then they would strike it down as violative of the due process clause. And that was the sort of minimal protection that began to arise under the 14th Amendment, but it was more under the due process line of analysis than the equal protection line of analysis. But what they did is they stated now, they started to generalize. I'm losing people hand over foot here. I must be I'm too far down into the weeds here, I guess. But the bottom line is that what they said is that for the black race and any other group of people who were like the black race in concept, that they would designate them to be a specially protected class. And if in fact they determined that a particular group was to be included in this specially protected class, they were going to have a heightened standard of review by the Supreme Court. They were going to review the state statute, and rather than passing the statute, if it had even a mere rational connection between the legitimate objective of the state in passing the statute with the discrimination that they put in the statute between the two different groups of people, that rather than having that mere rational connection in legitimate reason for the statute, they were going to require a higher standard in the case of any group that was like the Negro race. And that in that case, they were going to say they were a specially protected class, and the government interest that was being pursued by the statute under review, state statute, had to be a compelling government interest, not just a legitimate government interest. And they also, this is what they call the strict scrutiny test. They were going to strictly scrutinize a statute that discriminated against a group that was specially protected, like the black race. And they were going to require a compelling government interest as distinct from a mere legitimate government interest. And they were also going to impose an additional restriction, is that if there was a compelling government interest, they had to prove, the state had to prove, that the statute as drafted was the least possible restrictive statute of the rights of the minority group that was targeted, or that was the subject of this. It was the least restrictive means possible to effectuate the compelling government interest. But they imposed a third standard, and they said that the state had to prove that there was no class-based, invidious, discriminatory animus that was motivating the passage of that statute, because it was adversely affecting, comparatively, the interests of this specially protected class. So you see what now this is a moderate position that's being taken here. They're confining its application strictly to a group, the African race, and any other group like that, which would include, even based on the Slaughterhouse Case, would include Mexicans, it would include Chinese, at least, we know that much. But they said that the imposing of this stricter scrutiny on such a state statute was a device that was developed by the moderates, by the middle marginalist worldview people, because clearly the adherence to the sixth paradigm natural law worldview kept insisting upon the original intent. They were saying, look at the rights, privileges, and immunities of citizens of the United States include all the fundamental rights. The due process clause entails not only the procedural due process requirements, but the substantive due process rights that can be found to be essential for the due process. So in the natural law, advocates would argue that the equal protection statute that was passed, the 1870 Civil Rights Enforcement Statute, had the authority to prohibit the violation of these fundamental rights, not only by the federal government and the state government, but under the 14th Amendment, they were empowered to enforce them against private individuals as well. And they didn't get down to the point of whether it would be just one individual who violated your rights. They were willing to go along with the congressional decision that it had to be a conspiracy group. But that's what was being advocated by the adherents to the natural law worldview, the sixth paradigm worldview. And what the moderates kept saying to them is, look, you aren't going to make it. You know, you can keep arguing that all day long, but there's a whole line of, like, now almost 60 years of case decisions that are refusing to acknowledge what you're saying. So you have to come along with us. Let us help you out here. And what we're going to do is we're going to impose this kind of conceptual scheme on our review process. And we're going to be willing, if you'll join with us on this, to impose the requirement that any statute passed by the state that has any type of a discriminatory impact upon a specially protected class that are like the African race, we're going to require not just a legitimate government interest on the part of the state to pass the statute, but it has to be a compelling government interest. And additionally, we're going to impose the requirement that the scheme of the statute imposes the least restrictive possible burden on members of that specially protected class in order to effectuate the objective of the statute. and we're going to require that the state prove that it has no bias that is motivating them against that group that motivated the passing of the statute. Okay, so that was a very high standard that the state had to meet if it was going to pass a statute that had a discriminatory impact upon any such a special class. So immediately the question arises is, well, what are the other potential classes other than the African American race? What other groups might be entitled to this special standing? But you'll see that no matter what conceptual standards you have here, that the fact is the selecting of one group or another and putting it into that category is largely subjective. But the fact is that they've crafted, the middle marginalists have crafted a tight enough sounding conceptual schematic that it sounds like they're being objective. And so that what the first group was, and it wasn't until 1971 that they started adding these groups in. The first group to be added in was aliens. All people who are aliens or non-citizens who are here in the United States, the argument was that they had to be protected. They had to be given the same rights as anybody else. And if in fact there was a statute that discriminated against them, it had to be subjected to the strict scrutiny tests, looking for a compelling government state interest as distinct from a legitimate state interest, a minimal impact, the least restrictive impact on them, and that they had to meet the burden that it was not based on any racial or class-based animus. Yes, Sophia?
What is the definition of compelling here? Because you never really stated that. Obviously, it's different than legitimate, and it's a stronger qualification than legitimate. But how exactly? I know there's always kind of more complicated definitions than it seems when it comes to legal terms. So what is the definition of compelling here, and how is it different? Well,
that was my exact point. To make some argument, an intellectual argument as to what the distinction is between a compelling government interest and legitimate government interest isn't entirely clear at all. And you look at the different cases that are decided, and it's almost impossible to determine whether a given government interest is going to be designated by the court as compelling or merely legitimate. And that was what the problem was. And so what it did is it enabled the moderates to agree to include in the rejection of a particular state statute because they personally didn't find it to be compelling. Even if they had to acknowledge that it was a legitimate government interest, they didn't find it to be adequately compelling to justify a discriminatory impact upon a group so long as they were deemed to be specially protected. And the criteria by means of which they would be deemed to be specially protected, you could ask the same question. How is it that they're specially protected? Why are they? And then all they would say is because they're analogous to the African race. And in this case, the aliens, people who are not members of the citizens of the United States, was deemed to be subject to this special scrutiny. And so your question is a perfectly legitimate one. But what it did is it set up this extremely high standard to be met by a state statute, but for only a comparatively limited class of plaintiffs. That they had to be part of a class that was specially protected. And they made all kinds of arguments on behalf of that by saying a group should be designated as a specially protected group if they in fact had been historically subjected to irrational forms of discrimination that were not predicated upon any trait that could be actually attributed to all the members of that group. So that there were the phrase they use, there were stereotyping characteristics projected onto all the members of that particular group that in fact bore no rational connection to the way they actually were. And so that they began to search out where a lot of the debate, Sophia, that went on within the court as to whether or not they were going to apply this strict scrutiny test was more directed toward whether they're a specially protected class rather than how do you distinguish a compelling government interest from a legitimate government interest. So most of the cases debated this issue of whether they met the criterion of being a specially protected class and what made them like the African race. Because one might argue, by way of your paper, that, well, how are you going to make an analogy to any other group when this was the only group in the entire country that was enslaved and treated like they were not human beings, not only not citizens, but they were treated like they were chattel. So how can you have another class of people that could possibly be entitled to the same degree of special protection that they were? And that was the burden that the courts had. That was the burden they had, was to try to, but you need to understand that all of it is an attempt to design a rationale, because they already want to get there. They want to expand the groups that are protected out more and more toward those that would be protected by the natural law worldview, but they have to come up with some kind of rationale for doing it. And so the moderates on the court developed this concept of applying strict scrutiny to protect other classes. And that's what they did. Now, what they also did, while they were in the process of trying to figure out more and more groups that could go into this category of a specially protected class, they opened up another entire front, and they said, let's have another group of people, not the people that are an inherently suspect classification because of the clear way in which they relate to the African American people, but let's have another one that is just a suspect classification. Let's have a middle level of review, a standard of review for a group that is just a suspect as being prejudiced against. And then what they would do is, rather than having to have just either a legitimate government interest, which wasn't going to meet the test, but it didn't have to get all the way to having a compelling government interest. So you're going to like this one, Sophia. They only had to have a substantial government interest. And so how do you distinguish between a substantial government interest and a compelling government interest? And how are they distinguished from a legitimate government interest? But they did it. So that they, while they were adding more and more classes of people into this specially protected class and applying the strictest scrutiny to those state statutes, thereby generating a presumption that they're going to declare them unconstitutional, they open up this second front, the progressives. They open up a second front establishing a suspect classification and require that there be a substantial government interest is all. Not a compelling government interest, but a substantial government interest, or they would strike it down. And there also had to be a clear connection between the motive, the alleged proper motive for the statute, or the substantial government interest. There had to be a clear connection between that and the discriminatory effect that was being imposed upon the group. So this was a second category of protection that they generated, and then they moved successfully the adherence to the progressive worldview, because you got to remember now, these are all cases that began to come on after 1938, after Roosevelt rose to power and the Democrats took over the House and the Senate, and that they had this overwhelming majority, and therefore they began to appoint more and more justices to the Supreme Court and more judges in the federal court system, and so that the support for moving more back toward the natural law perspective, while still maintaining some sense of integrity that it was being compelled by some logical set of conceptual categories that they're dealing with. And yet when you push down to the bottom of it, you find that you can't really define a consistent objective criteria by means of which they're making these distinctions. And so what they did is they developed a third category, and that is that if in fact a statute had a disparate impact upon any particular group, even if they were not a specially protected group, but they didn't even have to be a suspect classification. But if any group ended up having a disparate impact imposed upon them by a particular given statute, and they found themselves, here's the other opportunity, they found themselves to be substantially similarly situated with all of the other members of the society that didn't have that disparate impact, that in fact it would be declared to be non-rational. So they were treated back to the due process, the substantive due process standard of it not being rational, but that they set up this other conceptual step of designating a group that was being subjected to a disparate impact of a statute, and they demanded that if in fact that group was substantially similarly situated to those that were not suffering the disparate impact, that became irrational. And that was the third category of scrutiny that they engaged in. And so, but then you started seeing the question arising as to how they were going to continue to expand the groups that were especially protected, which groups were going to be designated as, well, not an inherently protected group, but a suspect group, and then the other group that was just being disparatively impacted. Okay? And so that they began this process of including kind of selective inclusion again, that they went from African Americans to Indians, Native American people, to the Chinese, to the Mexicans, to the aliens. And then in 1968, you got this long period from 1932 in 1936 when Roosevelt started drawing in more and more Democrats into the House and Senate and held the White House, that they were able to maintain control of it and get more and more appointments to the Supreme Court. That what happened is that by 1968, they included non-marital children in this specially protected category. That there were a whole series of cases that came down from 1968 to 1972, and what they did is they had all kinds of cases where the children, the non-marital children, were in fact deprived of the right to inherit money or the estate of their natural parent, and they were struck down as unconstitutional on the grounds that this was a class of people that had been historically discriminated against. You know, the classic bastard category, that there had been an historical prejudice against people like that, and so therefore they were designated to be a specially protected class in the case of Levy versus Louisiana in 1968. The advantage that we had in that case is that Justice Douglas wrote the opinion, and Justice Douglas is probably the penultimate natural law advocate that's been on the court. And whenever he gets to write an opinion, you know that the Chief Justice, who has assigned the case to him to write the opinion, is moving more and more toward a natural law position on that issue. And so there were a series of cases in which they did this. Then they came up with a very interesting case in 1979. This is the case of Caban, C-A-B-A-N, versus Muhammad, and this was designated as a gender discrimination. Now, this is all while they're still refusing to recognize the rights of women. We're going to get to that category, obviously. But this was a case in which the New York State statute required the consent only of the mother in the event of the adoption of a non-marital child. So that if in fact a child were born out of wedlock and there was going to be an adoption, that only required the consent of the mother. And it did not allow the father to protest that. And so that, I guess it doesn't seem ironic to the women anyway, in the course who've experienced this, but the bottom line is they end up declaring it to be a violation of the equal protection of the laws to a man before they actually ruled that it was a discrimination against women, to be prejudiced against women as an entire class. So this is in 1979 in the case of Cabin versus Mohammed, and that's at 441 U.S. 380. Then they added into the especially protected class indigents, that any type of discrimination against people who were in an indigent category was deemed to be a specially protected class or a specially protected group. And on this basis, they struck down poll taxes and a lot of other things where people that were poor couldn't be expected to be able to pay these things, and it was an undue burden. And there was in California, there was a statute prohibiting any person from importing into the state of California an indigent person. And so that they made the argument that they had the right. The state of California made the argument that they had a right to protect the state because an indigent person, if they were brought into the state, were going to end up having to go on welfare. They were going to have to pay all kinds of money for them, etc., and provide them services without any kind of taxes coming back to the state. And they argued that that was a legitimate government interest. Indeed, they argued that it was a substantial government interest. But in fact, the majority of the court ruled that in fact it was they were a specially protected class, and they would have to show a compelling government interest, in that they were unable to do so. And plus, they went on to point out that from the legislative history of that statute that was passed in California, that the legislature had equated poverty with immorality. That somehow people who were indigent were somehow immoral, and that it was going to be affecting the public interest to have all these people here who were indigent and immoral. And so the court said that that was not rational, and that they struck it down. Now, so you come to this the big question following the issue of the trying to overcome the historical racial discrimination against people from the African race, that you come to the issue of the women. Now, this is, as we know, a terrible and dark history, third only to the history experienced by the African race itself and the Native American people here in the country. That the discrimination against women has been the longest standing, most hard-fought battle under the Equal Protection Clause of the 14th Amendment. And the kind of cases that were decided, there was a case called Bradwell versus Illinois, in 1873. In the state of Illinois, you're going to love this one, the state of Illinois refused to allow women to practice law. That they wouldn't allow them to take the bar exam. They wouldn't allow them to be entered into the state law school. And this is even after the Supreme Court had ruled that black people had to be admitted to the school. They said that women didn't have to be admitted to the school. And Justice Bradley wrote this opinion for the court. And I'll have to read it to you in order for you to believe it. He said, "The natural and proper timidity and delicacy which belongs to the female sex evidently unfits them for many of the occupations of civil life. The constitution of the family organization which is founded on a divine ordinance, as well as in the nature of all things, indicates the domestic sphere is that which properly belongs to the belongs to the domain and functions of womanhood.
When was this?
This was in 1873. This is 1873. This is approximately 8 years after the passage of the amendment itself. They're ruling that women are not protected under the Equal Rights Clause of the 14th Amendment. And they're saying that the harmony, not to say identity, of the interests and views which belong or should belong to the family institution is repugnant to the idea of a woman adopting a separate and distinct career from that of her husband. He says, he points out, it is true that many women remain unmarried and are not affected by any of such duties or complications or incapacities arising out of their marital state. But these are exceptions to the general rule. And the paramount destiny and mission of women is to fulfill the noble and benign office of wife and mother. Okay? So it gives you some idea of the distance that has been traveled since 1873. Not only in the field of black civil rights, but also with regard to the equal rights of women. But in fact, as you know, all the women know here anyway, that the effort to pass the Equal Rights Amendment did not succeed. That even though Congress, by a 2/3 majority in both houses, back in when it was in 82 that we were out in Oklahoma working on the Equal Rights Amendment, but it was they actually passed the Equal Rights Amendment through Congress in, let's see here, 1973. Yes, and so there was a period of time that we had in order to get the 3/4 of all of the state legislatures to ratify it. And what we did is we went through that period of time. Ellie Smeal was actually running the operation, the big campaign for the Equal Rights Amendment. Eleanor Smeal was the vice president of the National Organization for Women. Sarah Nelson, my wife, was the National Labor Secretary for the National Organization for Women. Because we had done the Karen Silkwood case out in Oklahoma and had done lots of organizing around that, and had also done the big organizing to stop the construction of the Black Fox nuclear facility in Oklahoma, we were asked to go out and run the Equal Rights Amendment campaign out in Oklahoma. And we did. And we got down to one vote. We were one vote away from winning the state of Oklahoma for the Equal Rights Amendment. And we had that guy's mother working on him diligently when the time ran out. But the fact of the matter is that because the Equal Rights Amendment was not in fact passed, the women in the United States now, that you only have equal rights pursuant to statutes for the most part. And so what happened is all the way up until 1973, there was a kind of a tight decision that was made in 1973. The case is called Frontire O Virtues versus Richardson. This is a case in the United States Supreme Court where in the United States military, males who were members of the United States military who were married were automatically given spouse dependency payments and given additional homing allotments. But women could not get those dependency payments or additional housing allotments unless they proved that their husband was in fact financially dependent on them and that they needed more space in the house for a family dwelling. And that was struck down But the four judges that concurred in this with Brennan applied the strict scrutiny test. They said that clearly women have been historically discriminated against, and they go into all the details in this Frontire O case about the long pattern of historical discrimination against women, and say that clearly the women should in fact be considered to be one of the classes that are specially protected. But the concurrence, Chief Justice Berger and Blackmun and Powell and Stewart, the other four justices, disagreed. And they thought that, in fact, it might be the women may be entitled to a middle level of review, the suspect classification, requiring a significant government interest to infringe on them, that they were entitled to that. And then, of course, Rehnquist dissented, saying that it's perfectly obvious that women aren't equal. Why should we treat them that way, basically? That's Rehnquist, who was the one who came up with that opinion that I told you about at the beginning of the class, that he upheld a practice on the part of a corporation that was a federal government contractor in discriminating against women by not providing them pregnancy benefits on the grounds that the pregnancy benefits were denied not only to non-pregnant women, but non-pregnant men as well. And so, but eventually, the granting of women by the court of a suspect category that were entitled to a heightened level of scrutiny by the court was ruled on in 1976 by the United States Supreme Court. And it pointed out in a major opinion that was written by Brennan, he said that, look, he said it's clear that with the passage of the passage by Congress, very interesting, he said with the passage by Congress of the Equal Rights Amendment, even though it's not been ratified yet, that the passage of the statute by 2/3 of the members of both houses, and the fact that over half of all the states have ratified it as of now, they were still in the process, he said that he was going to take the position that that the women were entitled to the status of a suspect category, and that's where it stands at the present time. So that the need to have an Equal Rights Amendment is very obvious, and it was extraordinary. All the way up into 1982, when the time expired in June 21st of 1982, on the campaign to get the Equal Rights Amendment passed, I was going to American Legion posts and in labor union meetings and everything else all through the state of Oklahoma, engaged in trying to persuade the men in the state of Oklahoma to support this. Sarah was organizing the women to support it, and the mothers and grandmothers and stuff of the legislators. But it was extraordinary how resistant the men were to having this amendment. And one of the things that they kept raising all the time was the fact that they thought it was going to result in women being drafted and having to go fight in combat, and that it was going to undermine the fighting integrity of our American military units to have women in the battlefield, because men would be instinctively trying to protect them. And would therefore not be protecting themselves adequately or pursuing the military mission assigned to them. It's an extraordinary reflection of the simple bias, deep-seated bias on the part of the men, and that the arguments that they come up with are so transparently bogus that it was hard to believe that anybody could believe them. But there were all kinds of statutes up until under that standard that was applied now by the court, that they actually began to strike down strike down statutes. There was an Idaho state statute in Reed versus Reed, in which, that's 404 U.S. 71, it was a statute in Idaho that said, it set up a hierarchy for people being able to be an administrator of a will if in fact a person died intestate or died without a will. And they set it up for, first it would be the parent of the person who died, and with no parent available, it would be a child of the person who died, or thirdly, it would be a sibling of the person who died. And in the event that there were two equally qualified people in one or another of those categories, and one was a male and one was a female, that the male had to be given the position. And the Utah, or excuse me, the Idaho legislature went on and on and on about how the women had so many other things they had to do. That they had to take care of the house, they had to do all the washing, they had to do all the dishes, they had to take care of all the children. This went on and on like that, and said that for that reason, we wanted to relieve them of this additional burden of having to be the administrator of a will. And so the court struck that down, saying that it was an unconstitutional discrimination against the women, applying the middle level standard, the heightened standard of scrutiny. And they said that there didn't appear to be that whole alleged interest that the state of Utah had in providing the freedom of women to just be childbearers and barefoot in the kitchen they said it was not a legitimate government interest, and it surely was not a substantial government interest, and so they struck it down. Then there were other statutes. There was an interesting statute that in Oklahoma that went the other way. They authorized the sale of 3.2% beer, and women could be sold beer, 3.2 beer, upon reaching the age of 18, but men had to be 21. And so the men filed lawsuit and said that this was a discrimination against them, and the Supreme Court struck it down as being an irrational, a gender-based discrimination. But the fact is, there were like 4 or 5 cases that were ruled upon striking down statutes that discriminated against men before the Supreme Court struck down laws that were discriminating against women. And so it shows you again the kind of inherent bias that is functioning beneath all of these sophisticated standards and standards of review and everything that they articulate. And the fact of the matter is, it's almost always eventually just gastronomic. And that they have this kind of gut feel of what they're supposed to do, and that they stay stuck in all kinds of deep and abiding levels of prejudice. And so that it raises questions about how viable and how effective these conceptual categories are that have been designed by the middle marginalists to attempt to construct conceptual vessels into which they can categorize one or another of the set of plaintiffs in order to clearly attempt to move away from the effort on the part of the reactionaries to pull our country back into the age where authoritarian rules and principles governed. And they're trying to pull the decisions more toward the natural law end of the spectrum. But what they do is they've crafted these conceptual categories that, in my opinion, it's quite a well-informed opinion and quite experienced opinion, are nothing more than just simply subjective categories. And it's how you're going to put someone in it. Yes, Sarah.
You just said that there's like an inherent bias under all like the makings of laws and like decisions in a court, and that there's an astronomic gut feel. But that sounds like how you describe it's supposed to be.
There you go. Good. See, you picked it up. That's exactly right.
But then, if it's biased, then if you're so saying like, oh, if it is natural law, the natural law is biased towards males, like, I feel like it would, like, be an opposing argument against natural law, because natural law can be dangerous to say, oh, this is natural law, this is what it's supposed to be right.
Absolutely. You're absolutely right. You're absolutely right. And that's why I read it. Because I said, look at this. In fact, there's an additional sentence or two that goes on in that decision about the women, where he said, you like this? He said, right here, he said, this is the law. This is after he said all this stuff about the women, that the paramount destiny and mission of women is to fulfill the noble and benign office of wife and mother. This is the law of the Creator, and the rules of civil society must be adapted to the general constitution of things and cannot be based upon the exceptional case. Okay? So that you've got your finger right on it, Sarah, that if in fact we are going to try to generate a regime that functions on the basis of rational, well-argued, intellectually framed concepts, how can we advocate some other kind of more what might be characterized as gastronomical, subjective beliefs on the part of the adherents to the natural law worldview? Aren't they just as biased and based on nothing ultimately other than gut feelings as the reactionaries are, and as the adherents to the authoritarian worldview are? And the answer, of course, is yes. But the thing is that each of them have a much better argument that can be made on behalf of them. And that's what the key to this course is about, is because if in fact you look to what the basic instinctive assumptions are that underlie either any one of these worldviews, what you find out is they come back to the issue of those four basic pillar questions. The cosmological question of how the universe came into being, the teleological question of whether it's unfolding in some meaningful way towards some predictable end that might lend derivative value to the process that goes on in the interim, and the ontological question of how consciousness actually came into existence in the material universe, and fourthly, the epistemological question as to what type of faculties do we have as human beings by means of which we can possibly discern the answers to those kind of questions. Okay? But what this does is this provides an intellectual structure pursuant to which all of the rest of your reasoning is completely consistent. And in fact, it can provide a schematic by means of which you can look into areas that you haven't thought about directly yet and apply the same rational standards that you developed and come up with an answer, assuming the answer to the four basic questions, because that we don't have definitive proof one way or another on any one of these four questions. And so what we're saying, the follow-up question you might have is, well, how does that make natural law, the natural law instinctive attachment to four internally self-referentially consistent answers to those questions, how does it make it any better than the reactionary worldview?
I would instead say, like, you're setting up an algorithm to figure out how one person would think or how someone would think, but we've evolved, and I mean, even if you believe in evolution as possibly like a species, like a human species can evolve, like there's obviously like physical changes. The way people think must have evolved, like also like on regional levels. So this community here, which has evolved like hunting, they probably see things sharper. Maybe they think like this. Like, I don't know, like they think like triangles, and someone else might think like circles. It's hard to explain, but it's like you set up an algorithm.
Well, but that is your task in this class, is to explain.
Okay, then say I look at a picture and the first thought that goes in my head is like, ooh, I see blue and I see a duck, and someone else looks at a picture and they think, wow, I see a storm. It's just different. Like your algorithm may work to like, oh, how you answer these 4 questions, this is how you're going to answer. This is what you're going to say to this question. And that might work for a set of people, but you go across the globe, they might look at those 4 questions and say, what are you even talking about? Like, I don't agree with any of these answers, and here's what I think. Or maybe they give an answer that you would say, oh, well, then you're a second worldview, and they have answers they look at a solution, and they see a problem, they find solutions that you'd put, oh, that's a reactionary worldview. You must actually, and it's just different. Like,
so far there are probably 6 separate things in there that you've said that are each segregable and meritorious in being addressed. But it's hard to do all 6 of them in an answer. But the bottom line is, as I've said before, it's entirely possible for a person to sing an entire song completely off key. Sure it is. But the fact of the matter is, if they sing the song on key, the fact is 99% of the people will respond to it in a particular positive way. And if they don't, if they're off key all the way through it, it grates on people's nerves, and they get up and walk out.
But there's so many different keys.
Well, but they're consistent. That's exactly the point that I'm making. That they're consistent. There's an internal logic to a certain system, and that they may be different, but it's a logic inside the system. What we're looking at here is trying to figure out what value, what light can be shed on the entire process of the court systems and the law in dealing with the fundamental reality of the fact that right from the very beginning in our country, there have been these 2 substantially different worldviews that are attempting to espouse their objectives. And so what we're trying to do is to figure out whether or not we can parse these in a way to ascertain what it is that's causing them to be like that. So we can figure out what to do, how we can respond to this. Okay? And that's what this is. That's what this. I got good hands are going up everywhere now. Okay. Now yours. Yes.
So how do you know though that there are only 8 consistent sets of answers? I feel like we kind of skipped over the methodology where you'd show us how you developed this system. Yep.
Okay. That's another great question. And the answer to that is that there are the schematic that was designed originally by Talcott Parsons that I mentioned to you. That Talcott Parsons had 5 of these categories. The right systematist and the left systematist and the left marginalist and right marginalist and the middle marginalist. What I did is that when I undertook the master's degree studies at Harvard, working with Rolf Potter, began to analyze these things and saw that there were if you looked at the belief systems of the people that Talcott Parsons had put into these 5 different areas, that he was leaving out the conservatives and liberals. The conservatives and liberals, if you looked to as you remember, you can cut into this schematic at any point. You can describe the schematic in terms of their political worldviews, from authoritarian to reactionary to conservative to moderate to liberal to progressive to utopian. You can do that. You can cut into them in the area of philosophy. You can cut into them in the area of their ontological views. Okay, you can cut into them anywhere and describe the whole set of them. But what happens is you see that five of the different categories don't really account for other thoroughly consistent positions. There's a thoroughly consistent conservative position and a thoroughly consistent liberal position, which were just being left out. And when you get to all 7 of those, when you add those 2 in to the 7 of the scheme, then you have to come back with, and here's the answer to your question, because this is we're getting to the stage now in the course where you're going to start asking these really important, deep questions. And the answer as to why I have talked about this octave is twofold. One is because if you research all of the deep history of the chakra system in the human body, that you find that there are 8 separate chakras systems. And there are 8 dominant systems in which these function. And they say so over and over and over again in the Hindu faiths and in the Buddhist faiths, in that there's a physiological, phenomenological basis for the way that people act. Okay? And that so that if you look at it in that manner, that there are all kinds of octaves in which things occur in our particular, in my opinion, at the particular wavelength of frequency, the area in which we manifest physically as human beings, the frequency, vibrational frequency within which we manifest in the material form as human beings, in fact, gives us access to differing vibrational frequencies. Okay? Like the difference between the vibrational frequency of light that you can see in your eyes, the vibrational frequency of sound that you hear in your ears. You know, that these are faculties that we have, so that the reason for the structure of this in the form of an octave is that in fact you see over and over and over and over again in nature things occurring in octave sets. And there's a whole kind of set theory to this, okay? And that we can get into it a lot more afterwards. But that's a perfectly sound question. But the answer to your question, Sarah, still is that inside these 8, you can actually identify completely categorically distinct positions on all 4 of those basic fundamental questions. You can actually derive 8 completely different sets of completely internally and self-referentially consistent answers to those questions in 8 different worldviews that all flow down from that, and they generate a particular, for example, a particular cosmological assumption will in fact generate a concomitant logical, teleological answer to that. The same thing happens with the other answers. But that's a great question. What's your follow-up? I see it.
So the methodology was worked out in your master's work, if I got that right?
Yes.
Is that available to read anywhere?
No. Actually, the problem is that I rolled over into the PhD program without writing the thesis. But I've got a 1,500 page draft of it, which I'd be happy to share with you. Yeah.
I mean, I'm stuck up on accepting the system, and I can't tell how it's developed.
No, which is exactly what the critique is that I'm directing toward the construction of these conceptual categories that the middle marginalists are designing, because they seem to be subjective, and you can't really. It gives you no predictive quality of being able to determine what's going to fit into them, right? Because they're subjective. But what I'm arguing on behalf of the octave schematic is that at least once you arrive upon, you can demonstrate, for example, that any 4 particular answers to those 4 pillar questions either are or are not internally and self-referentially consistent. That you can do, okay? And then you can, in fact, determine whether or not it's an accurate discernment that the answers to those questions generate a particular principle that is common to all of them. And then you can also determine whether or not the application of that principle to a whole range of practical questions in life end up providing you a principle that is consistently available to answer those questions ethically, so that you actually get a consistent mode of ethical reasoning that is generated from that. And then you can demonstrate in turn that that particular philosophy that is generated by the application of that principle to these life situations generates a particular political theory. There's a particular political theory that is derivative of that philosophy, or a different political philosophy. So what I'm saying is that the advantage to this system is that it in fact correlates with the octave of chakras that are articulated in profound cultures of Buddhism and Hinduism, that it in fact is completely logical once you have a an intuitive discernment of what the answer is, in taking into account all the best science that you can get. It's absolutely clear that if we were able to establish scientifically exactly how the universe came into being, then we're in a position where there's going to start to become an extraordinary threat of authoritarianism. Because once we get the answer to that, it starts to eliminate other answers that are inconsistent with that. And so it's going to generate consistent answers to the other three questions, and then it's going to generate a specific principle and a specific mode of ethical reasoning, a particular philosophy, a particular political philosophy of one of these. But what this is that these are also, I'll say just in closing, we can talk about this much more, that the 8 worldviews that are here are all ones that you hear discussed all the time. This, the authoritarian worldview and the reactionary worldview, these are worldviews that you hear discussed all the time, and nobody explains what they mean. You know, they're just kind of these subjective terms that are thrown out. And what this is an attempt to make rational the content of all of these. Okay, but we have to go. We can have all these questions over at the other section. We just don't want to take up everybody else's space here, okay?